So I'm ready, but I pray if it comes on the 7th or 10th.
Not a regular bench, sir. Our memo, sir.
No, I'm filing my Wakalatnama today. I'm not my name. Yes, my lord.
Maybe I am not audible.
My lord.
I am not sitting single. No, I have no assignment. So allowing memos has a difficulty for me
this
because
is not a memo. This is Wakalatnama.
I understand, sir. I understand, sir. But that Wakalatnama you are filing in which matter I do not know, sir.
Item number 19. 19.
So you file it in the registry. No difficulty.
No, provide it is otherwise the matter would reach.
No difficulty. It can be adjourned, sir.
So therefore I seek.
Please appreciate, sir.
Then I seek for an adjournment then.
No difficulty, sir. No difficulty. Anyone seeking any adjournment, since I do not have assignment.
Oh,
I cannot adjourn matters of other benches. This is only a single day. It's a kind of an arrangement.
Oh, so my lordship will not take 19. I only pray that 19.
No difficulty. No difficulty.
Obliged. Deeply obliged.
Younger colleagues, they will inform me. 19 mandakti sir, I will simply adjourn it to file it. No difficulty.
Okay.
No difficulty. Because I also understand that.
Yes, I
understand. It is only a one-day assignment, so any one of you can. In fact, I have some difficulty in sitting for long time also.
No, I agree, Lord. But I only
see that another way of looking at it.
Should not be taken up. 19.
No, definitely. No. Any Lord Council present here who do not want the matter to be adjourned because it's a single day assignment.
Yes.
There are other issues also. What the Lord Council are facing difficulty. Once this is taken up by this bench, subsequent listing is happening when I am sitting single.
I wanted the matter to be taken by my lordship. Why my lordship would appreciate the law.
I will be indeed happy to, but I have not been assigned that way. So the difficulty also is there. I understand.
But
once the matter, what the listing section does, once this bench issues notice, it keeps the matter pending, and till the next sitting. That is not exactly assignment, but that's a kind of a norm they are following.
Yes.
It is a little bit unusual, but that happens always.
Then my lordship would adjourn.
No difficulty.
Deeply obliged.
Item 13, my lord. Item 13 also I pray for an adjournment.
Page wise, sir. Let us go for page wise. Since this is a single day assignment, I understand. Page wise, sir. Let us go.
Supplemental list, page 1.
But only request. Only request which are tied up and tied up to this bench. If you adjourn those matters, I cannot assure you a date. Whenever I will be sitting single sometime, definitely, like today. So then it will be listed. So kindly appreciate. I cannot fix it at chamber or at 4 p.m., 4:15, 4:30 because I am sitting in a division bench. Earlier I used to do that, but I realized that I cannot, the impact of breaking a division bench because the senior judge is there. So that's there. Page 1 to 11.
Item 8, my lord. Who is that?
Mr. Samal is not there. You are Mr. Lenka.
Yes.
Item 8, Mr. Lenka, B. Lenka for the petitioner. Mr. 8, Mr. Prem Kumar. Mr. Prem Kumar Mahanti for the ASC for the state. देखिए 1, 2, 3 as requested by the Lord Council for the petitioner, the matter stands adjourned. Liberty to mention. So liberty, you may face the difficulty because you may not face difficulty in listing before the assigned bench. There is some problem there also. So that is how the liberty. Yes, next sir.
Page 12 to
Item 12, my lord.
12. Okay. Next page.
My lord, item 6.
First page रे अछि 1 ରୁ 11. आपण केते कहउचंदी?
My lord.
Please speak to the microphone. Come forward. For adjournment, you should not be scared. When I am saying that though I do not adjourn matters, but today I am, since it is a one-day assignment, you can adjourn. Item 7, your name, madam?
Sujata Rani Ponda.
Mrs. S.R. Ponda.
Yes.
7. Prem Kumar.
Yes, sir.
7 say. 7 gala. 7 gala. Tapare 8 gala. हाँ ठीक है. Any other matter in the first page? Then the second page, item 12.
Item 12, man.
Same. Mr. Sahoo. Mr. S.K. Sahoo. 12 रे S.K. Sahoo. 12 रे की अछंती S.B. Ponda. এটা যদি municipality থিবে additional commissioner BBSR जो লেখা হয়নি এটা municipality ହେଇଥିବ ଦେଖିକି ଲେଖିବେ Mr. Panda is appearing for continues to appear for municipality no more appearing he used to appear for BDA and okay SB Panda ঠিক আছে item 13 to 25
Lordship, item 16.
16 your name sir
Adarsh
Nandan.
Biswal. A. Biswal.
A Bishwal
Yes, sir.
16 হচ্ছেন A Bishwal Panda Mr. SB Panda
Yes.
SB Panda yes
Item 13, my lord.
13 sir
Item
Vinay Kumar Mahanti yes Vinay Kumar Mahanti
Yes, my lord.
After Vinay Kumar Mahanti Mr. SB Panda
Yes.
My lordship may urgent that matter, my lord.
yes liberty to mention but if it is a tied up matter to this bench please consider that so it should be taken up otherwise there will be difficulty again after some time anyway which is not tied up then no difficulty liberty to mention 13 it will likely Vinay Kumar Mahanti being present at virtual court High Court of Orissa at Jagatsinghpur
Yes, my lord.
so you are doing the trial court matters on Fridays
My lord, today I am suffering from illness, therefore,
but suffering from illness should be at Cuttack and get treated
my lord, my residency is at Jagatsinghpur, my lord.
so that is how you are staying in Cuttack also
Correct, my lord.
both ways having benefit of the both
Recording in progress.
ସମସ୍ତେ କଣ ପଣ୍ଡା ହେବେ ମହାନ୍ତି and ପଣ୍ଡା ଦି ଜଣ ବିନୟ କୁମାର ମହାନ୍ତି being present at virtual court High Court of Orissa at Jagatsinghpur addresses arguments as prayed for ସେଟା ସମାନ ରହିଲା yes next items then 14 to 25
Item 29, my lord. I'm applicant.
just 1 second 25 ରେ କେହି ନାହାନ୍ତି ନା next page
Page 3,
26
to 31.
Item 29, my lord. I'm appearing on behalf of Mr. Arun Kumar Acharya.
Sir.
My lord, this matter kindly
Sorry.
taken 1 week after.
adjourn it because if it is a tied up matter I do not know then it has to be whenever I'll be your name madam
Mona Lisa Mohanty.
Mona Lisa Mohanty on behalf of Arun Kumar Acharya for the applicant for the applicant এটা disposed of
Dispose of case.
oh for petitioner लिखिए BLAPL रे other side inform other side to state out
State.
Mr. Mahanti Mr. D Mahanti AGA ଏଥିରେ IA ଟା
I copy ଦେଇ ନାହାନ୍ତି।
अच्छा हो ठीक अच्छी IA 9 of 2025 ना कोटा
Aye.
नहीं 19 हो ठीक अच्छी
19 of 25.
अच्छा तो किसी मेंशन करो करने से तो ना है तो सी भी तो क्वेश्चन किया the disposed of matter has been listed due to filing of some IA the Learned Counsel I'm sorry your name
Mona Lisa Mohanty.
Ms. Mahanti on behalf of Sri A.K. Acharya Learned Counsel who was appearing in the BLAPL for the petitioner seeks adjournment as prayed for the matter stands adjourned liberty to mention but Ms. Mahanti if it is a tied up matter it will be listed again before this bench no I am not saying but I am just bringing to your notice since you are a young counsel you must understand that yes next please 30 31 32 call the list
Supplemental list, item 1.
division bench किसी होनी
Vote not.
only one
Vote and
but yes for conference
only true. Vote not 20 is something.
Mr. Behra please
My lord. Order passed by this honorable court. For
interim order na final order
My lord.
interim order na final order
Any final order, yours.
Mr.
Final.
Vijay Kumar Behra for the petitioner
My lord.
It is regarding the fatigue that Rohit The Pujari.
Rohit Pujari, how?
He then
That the
minister.
then appellate authority, your lordship. At the
He
time,
then minister.
the misgender party. It's a quasi-criminal proceeding.
What
He's saying something in your favor. In
second?
a quasi-criminal proceeding, if you are a wrong party and the court proceeds, the order is illegal. We should be always make discussions legally nuanced.
Has to make a secretary.
Whoever is the party, that a proper party has to be there in a quasi-criminal proceeding. Even civil matters also, non-gender is a fatal. Non-gender, misgender in a civil matter also fatal. Content is a quasi-criminal proceeding. So there is no point in Mr. Behra, learned counsel for the petitioner, seeks accommodation to obtain instructions regarding the proper and necessary opposite party whom he shall implead. Accordingly, the matter stands adjourned, liberty to mention. But also check content assignment. Earlier content assignment was, now I think it should go before the assigned bench.
this is
ଆଜ୍ଞା ସେଇଟା ତ ଜଷ୍ଟିସ ସିହ୍ନାଙ୍କ ସମୟରେ ଥିଲା ଡିଫିକଲ୍ଟ ହେବ ଲିଷ୍ଟିଂ ଏଇ ପ୍ରୋବ୍ଲେମ ହବ ନାଇଁ ସେଇଟା ମୋର ଥିଲା ତ ଆଇ ହାଭ୍ ଇସ୍ୟୁଡ୍ ଇନ୍ ଫ୍ୟାକ୍ଟ ସମ୍ ହାଜ୍ ବିନ୍ କମ୍ପ୍ଲାଏଡ୍ ଅଲସୋ ସମ୍ ପର୍ସନାଲ ଆଫେୟାର୍ସ ଆଇ ରିମେମ୍ବର ବଟ୍ the present CJ thought that it will be appropriate that if it is going to the assignment so that the matter can be listed. Okay, ଆପଣ ଏଟା ପ୍ରପର ପାର୍ଟି କରନ୍ତୁ ହେଲା
by filing an amendment application.
ରାଇଟ୍ ଆମେଣ୍ଡମେଣ୍ଟ ଅଫ୍ କଷ୍ଟାଇଟଲ ହେଲେ ବି ଚଳିବ
Costed.
ଯଦି ଆପଣ ଆଭରମେଣ୍ଟ କିଛି ଚେଞ୍ଜ କରିବାର ନଥିବ
Only amendment of one costed.
ମିଷ୍ଟର ରଥ ପ୍ଲିଜ
Here also I have one time to file an
Okay.
cost item.
Okay. Same order. Item 2, Mr. Durgesh Narayan Ratha for the petition. Opposite party black रहेगा. Mr. Mishra, JK Mishra.
Item 3,
Second.
इतने proper party अच्छी थी. Or you take instruction. Okay.
What it is second one?
Whatever it may be, you make him party. Second content, first content तो बता ना हो नहीं. First content रे ही जिनसे चेष्टा करा होची comply करेगा पाए.
First contempt, sorry.
हाँ सर.
Now it's
But you obtain the I mean maybe one thing you can do earlier and the present both you have to include here. Since you are saying it is a second content, technically the second order has not been complied with. So in one content petition you have to make both the parties and allegations against both. Do it. Same order. Because I am not saying that whether the party is correct or not. I am simply saying that verify and impede the party.
चौबीस में सर फिल्म बना आप निश्चय चेंज हुई
Oh. First order का जोड़ा non compliance है जेटा है content. Second रे content petition टा dispose of है.
डायरेक्ट
से order टा भी हाँ comply से जो order टा भी जोटा सेटा again आउ present कियो ताकि party करी परियो अपन. Technical. But instead of that, जे बर्तन current incumbent अछन ताकि जनों को party कर दियंतु let us सेटा better. Yes, Mr. Patnaik.
item 4,
Yes, please. Mr. D.N. Patnaik for the petitioner.
ଆମେ
The affidavit file करना है state. Mr. Prem Kumar.
Which time may be allowed? File the account. Already parallel.
सर ये तो डिफिकल्ट आपण कर देले सर देखंतु मोर सिंगल बेंच होची कदबा कोची तापर ता देरे हो
Parawise comment is
मिस्टर
there.
पीके महंती प्रेम कुमार महंती एडिशनल स्टैंडिंग काउंसिल सर पर म्यूटेशन केस से इंस्ट्रक्शन दे दी थाते जे केते दिन नेबे कोन
Is there, madam?
Difficulty.
अच्छा तल सी जानिया दरकार हो ठीक अछि
There is a difficulty.
सो दे हैव गॉट इंस्ट्रक्शन देयर इज समथिंग इज देयर व्हिच यू हैव टू नो
I have sought for the civil court decree or they may parcel the civil court decree. That is
लेट अस ओके गॉट इट इतरे डीएन पटनायक और Mr. P.K. Mahanti, ହେଲା? The learned counsel for the petitioner refers to the earlier orders passed by this bench dated 28/2/2025 and 9/4/2025 and submits that the affidavit on behalf of the state has not been filed. Para. The learned additional standing counsel submits that he has received Paraway's comments and instructions regarding the state regarding the reasons for pendency of the mutation case. Given some time, he seeks time. He seeks time to bring the said instructions on record by filing affidavit. as prayed for, further 2 weeks time granted, liberty to mention. But you have to again, the same problem, the petitioner, out line, liberty to mention, the petitioner shall have liberty to move the assigned bench for listing of the matter.
Okay. One thing,
Please.
in this case, mutation is already disposed of, dropped. That till date, they are stating that mutation case is pending.
ଆଜ୍ଞା ଯଦି ଆପଣଙ୍କ ପିଟିସନର ଲାଭ ହଉଛି ଆପଣ କାହିଁ ବ୍ୟସ୍ତ ହଉଛନ୍ତି? ସେ ଯଦି ମ୍ୟୁଟେସନ କରିବେ ଆଉ ଥରେ ନୋଟିସ କରିବେ ତ ଦ୍ୟାଟ ଇଜ ଦ ବ୍ୟୁଟି ଅଫ ଲ। ଆଉ ଯଦି ସେ ଆଉ ଥରେ ରିଇନିସିଏଟ କରିବେ ତାହେଲେ ଆପଣ କେସ୍ ରିଟ୍ ଫାଇଲ କରିବାର ନଥିଲା, ଆପଣ ଆଉ ଗୋଟେ ମ୍ୟୁଟେସନ କେସ୍ ଟେ ଫାଇଲ କରିଥାନ୍ତେ। Many times that is happening. So once you file in High Court, they will say, "Again, High Court re file ହେଇଛି ଆମେ ତ କିଛି କରିବୁନି." That is happening. Could be.
item 5,
Yes, please. Mr. P. Patnaik for the petitioner.
Already instruction is there.
Same order, tale 2 weeks.
No, instruction is there, my lord. They have stated that even the petitioner has not filed any petition along with the copy of the order of director passed in RC number 6 with regard to the initiation of the Balia concentration of the issue notice to the parties hearing. It has been mentioned here that the said Balia concentration are already closed since 2016, January 2000. However, after
Saying a short affidavit kar diyantu so that he will be satisfied. He will ask his client to go through the affidavit. It will be disposed of.
They had not known that certain case has been filed, my lord. Therefore, they knew after the
Notices were issued in the petition.
my lord.
ଆପଣ ସେଟା ରେକର୍ଡରେ ଆଣନ୍ତୁ. You will take the responsibility.
I will file affidavit, my
My
lord.
lord, I humble respectful
Please,
submission before your lordship. As my knowledge is concerned, they have constituted a new case. Now, they have lost that case and original record is not
Could be.
available. And
You are right.
constituted
In fact, so I was prophetic. I was addressing Mr. Patnaik the same thing. So ନୂଆ କେସ୍ ଟା ଆପଣ କରିଥିଲେ ହେଇଥାନ୍ତା. So they have done the same thing. So let him bring that on record. ସେଇ ଗ୍ରାଉଣ୍ଡରେ dispose of ହେଇଯିବ.
My lord,
Because these matters kept pending in High Court is actually not serving purpose. But you have heard what Mr. Mahanti said that after we issued notice, they have sprung into action. ସେଟା ବି ହଉଛି. That is happening.
they have reconstituted. So for my
Already
So ସେମାନେ
Notice has been issued.
but that should be matter of record. So an affidavit diyon.
my lord,
Same order tale. Same order as in item 4.
that is in dormant condition. That is my whole phrase.
My lord, already notice has been issued on that case, my lord. Fixing 8/8/2025.
So shall I dispose of the writ petition, Mr. Patnaik?
With a direction to dispose of within stipulated time.
Stipulated period is difficult.
My lord, that
Because in Bhubaneswar in one matter, when I asked them for instruction, they reported
sufficient time.
27 or 40 cases are mutation from one plot is pending, all are interrelated.
My respectful submission to that regard,
As expeditiously as possible.
as expeditiously as
Diyon sir,
preferably within
diyon.
Period of 3 months, my lord.
ଦିଅନ୍ତୁ ଆପଣ 3 months ମାଗନ୍ତୁନି ମିଷ୍ଟର ଆପଣ ଅଦର ସାଇଡରେ କାମ କରିନାହାନ୍ତି ବୋଧେ କେବେ ଯାଇକି ମ୍ୟୁଟେସନ କେବେ କରନ୍ତୁ ଗୋଟେ ଜାଗା କରନ୍ତୁ ତାପରେ ଜାଣିବେ କଣ ହୁଏ I was because Patnaik for the petitioner. You have the same name as the great Swamiji.
my lord.
Pragyanananda ji. जी रेवन सर पढ़ौतले.
My lord, my grandfather is giving that.
No, actually same name. जी रेवन सर जी ना पढ़ौनतले in our days तापर छाड़ देले. He now health Kriya.
He is from Barampur and he is also related to us.
Professor Triloki Das. The name Triloki Das. The Todd Pragyanananda.
Pragyananda tame bhul re kouchon. Odia, he is Pragyananda. The same name, sir, is having. The learned counsel for the petitioner refers to the order dated 21/7/2025 and submits that state is to provide instruction. You take your seat. Apna bosun. In response, the learned additional standing counsel submits that he has obtained written instruction from the additional sub-collector Jagat Singhpur, UP number 2, received by him by office letter number 316 dated 29/7/2025. The contents of the instruction, a blue tick rate that we can get. The contents of the instruction is reproduced here. That would be relevant for adjudication of the matter. It is submitted by the learned counsel for the petitioner that as per his instruction also they have reinitiated. They have set the case into motion, pending case into motion, and the matter may be disposed of, directing the authorities to take a decision at an early date. The learned additional standing counsel in response submits that since the matter involves adjudication after issuance of notice to all the affected parties, it may take some time. And given some time, given reasonable time, the authorities shall do the needful for disposal of the matter. The instruction dated 29/7/2025, copy of which is filed along with a memo, is taken on record. Taken on record. Having heard learned counsel for the petitioner, the learned additional standing counsel, and considering the written instructions, the writ petition is disposed of. Observing that the authorities shall do well to dispose of the pending matter strictly in accordance with law as expeditiously as possible, preferably within a period of 6 months from date of communication of the certified copy of this order, certified copy, official website copy of this order. Urgent certified copy as per rules. It is clarified that this court has not expressed any opinion regarding the contentions raised in the writ petition or the contentions of the parties to the litigation. Yes, please. So, खोली की जरूरत कोई सारे करे दे. हमारी machine नहीं होगी. चढ़ नहीं करूँ. Correct. Next.
6.
Password कर दो. 7-8 order question है पर तो नहीं जाए चलते हैं.
Item 9.
Mr. Pandya, Mr. Mahanti, both the Mr. Mahantis. If you adjourn the matters to pass over, you will have any difficulty?
No.
Because you have to come back again to court. You have to accommodate your friends or any one of you can even present if you again call the list at 2 p.m. Yes. No, Mr. Swai once pointed out this because they have to wait for the entire day and you have work for issuing the letters and all that. Mr. Sanjeev Swai, and he is correct also.
Adjusted before.
List will be adjusted. But since we are passing it over, what is the that's the difficulty. Item, Mr. Choini,
Item 9.
he was present here. Pass over to
10.
Call Karantu.
11.
Not in this matter, Lordship directed for written instruction. But
Yes.
written instruction is yet to come. Lordship grant some more time. I will personally make endeavor to obtain that instruction as expeditiously. Regarding the status,
You are Mr. Das.
I am appearing on behalf of Mr. Das.
Your name, sir?
Lakshmikanto Behra, sir.
Power 9.
Power to 9, sir. But
Mr. L.K. Behra. You are writing L.K. or L. Behra?
LK Behra.
Mr. L.K. Behra on behalf of P.C. Das for the petitioner. Mr. S.B. Panda, AGA for the state. And counsel for the petitioner refers to the earlier order dated 21/7/2025 and submits that state is to provide instructions. The learned AG in response submits that he has sought for instruction and may be accommodated further. As prayed for, the matter is adjourned, granting time to state to obtain instruction, to provide instruction, granting time to the opposite party state to provide instruction. The petitioner shall have liberty to move the regular assigned bench. 2 weeks. 2 weeks, Mr. Panda.
my lord.
2 weeks.
Population.
12, 13.
Page 14 the queue.
Item 14,
May please, my lord, I am on VC Miller.
Yes, next.
15,
14.
16 jaichi. 17 dakantu.
17,
Dakantu. Next,
18.
next, please.
19, 19, 19 rise and
19 tere simply adjourn kar diyantu. 19 the matter Mr. the 19 tere me Rai sir kahitile.
mention.
Mr. PK Rai for the petitioner. Opposite party blank. The learned counsel Mr. Ray submits that he has been entrusted with the brief today and may be accommodated. Accordingly, the matter stands adjourned. Stop. Petitioner shall have liberty to move the regular assigned bench for listing of the matter. Yes, next, please.
Item 20,
Pardon your lordship. Lordship, item 15, my senior is come. Just arrived.
Yes, we have passed it over. Don't interrupt when the matter is called.
Pardon.
Yes, next.
21,
I will feel it.
Mr. Vibhuti Bhushan Mishra for the petitioner. Mr. S.P. Panda.
My lord.
Is 21 you are there, Mr. Panda?
Yes.
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 And I have challenged the order under Annexure 7
Yes.
passed by the ATM board. Thereby,
No appeal is there, sir.
well, appeal was filed.
Against this order, revision, appeal, anything
No revision.
to collector? Because they have amended further or it has not been amended.
Registration, as per registration manual,
So he is the appellate authority.
he is the appellate authority. ADM is the appellate authority. By virtue of the order of this honorable court,
Oh.
I approach the appellate authority. The appellate authority had rejected my appeal.
Okay. Mr. Vibhuti Bhushan Mishra for the petitioner, Mr. S.P. Panda AGA for the state. Apparently, the writ application has been filed challenging the order dated 28/5/2025 passed by the Additional District Magistrate Board in RMA number, all capital, RMA number 9 of 2025, by which order the petition ସିଏ କଣ 226 ରେ ମୁଭ୍ କଲେଣି?
ସେଇଟା ବି ମୁଁ ଦେଖୁଛି ବର୍ତ୍ତମାନ ସେ କଣ ଲେଖା ହେଇଛି।
ସେଇଥିବ କିଛି ବଡ କଥା ନୁହଁ।
226
କଣ କେତେବେଳେ ହେଇଯାଉଛି କିଛି କହିହବ।
ସରି
ଆମେଣ୍ଡମେଣ୍ଟ ହେଇଗଲାଣି।
ଇଚ୍ଛା peculiar ଜିନିଷ। I miss. I think out of WPC
ନା
ସେମିତି ବି ନାହିଁ।
In the matter of
under 226
ଆରେ ଆପଣ ଓଡିଆ କଣ ଆପଣ ତ ଓଡିଆ ମିଡିୟମ ଯୋଉ ପ୍ରକାର ମାମଲା ଆପ୍ଲିକେସନ ଅଣ୍ଡର ଆର୍ଟିକଲ 226 and 227
ଉପରେ ବି ଲେଖା ହେଇଛି। ମୁଁ ଭାବିଲି ତ ଉପରେ କୌଣସି ରିଟ୍ କୁ ମେନସନ କରି ତଳେ ବି ଲେଖିଛି ଟୋଟାଲି
complete non application.
ନେଭ୍ नो ଭାଇସ୍ କି କଣ ନା କଣ
So it filed under section 72 of the Registration Act 1908. But
Thank you, Mr. Mishra, that at least you have saved the situation. Not Article 226. Call लिख ले. Last. Additional. Comma, subsidy, comma, a petition under Section 72. 72 of the Registration Act 1908 has rejected the petition.
Appeal, it was appeal.
Has rejected the appeal. Rejected the appeal. Then Shappara. In the appeal before the ADL, the petitioner had challenged non-registration.
Yes.
Non-registration of a sale deed. Sale deed dated 28.01.2025.
I know.
Sale deed submitted on 28.01.2025 by the district sub-registrar both under the Registration Act. Issue notice along with this order. Put a line add issue notice. It is submitted by the Learned Counsel for the petitioner that the order is unjust and illegal. The order is unjust as it has not taken to the facts. Sorry?
Perverse, your lordship.
It is perverse as it has not taken into the relevant provisions of law into consideration.
But what I was apprehending, that is also be reflected in the first paragraph. He referred to a writ petition.
So that I have read.
But the
so that is fine. But he has passed the order under 226 and 225.
He should be careful. He should be careful. Definitely.
He made Mr. Biren Tripathi perhaps before passing the order. Mr. Biren Tripathi assured him that you can exercise jurisdiction under 226 and 227. He exercised jurisdiction.
Lawyer's persuasion. We are also equally responsible.
As it has not taken note of the relevant provisions of law and materials on record. You should notice along with this order. Private seller
not included.
I am Mustari party karna Okay.
Not a necessary party.
The Learned AG upon advance copy served appears and waives notice on behalf of the opposite parties. You require any extra copy?
No. I love it.
He seeks further. He seeks time to obtain instruction. Records. As prayed for 3 weeks time granted.
4 weeks.
4 weeks. 4 weeks time granted. The opposite party, if so advised, shall file their counter. Opposite party number 2, if so advised, 2 and 3, if so advised, the next date, copy of the counter, if that may be filed, shall be served on the Learned Counsel for the petitioner. The petitioner shall have liberty to file rejoinder in response thereto. The petitioner shall have liberty to move the regular assigned bench for listing of the matter.
It's a date.
Because it's not an assigned bench, that's a difficult. Again, these problems. You see, since February, they are not listing the matters. They should have listed the matters, but they are not listing. They are waiting for this single bench to function.
I don't have any interim prayer. So
no, but even, I don't understand this.
All right.
Yes, please.
22.
Challenging reliance of the opposite parties, person not deleting the remarks, the Jabardat upon the remarks are based ways.
What is the case number, sir? Which case? Upon case quota question. Revenue record without initiation of a case, it cannot be corrected. Because the Tahsildar doesn't have power.
No. I will say.
No, sir. Can you tell me the case number, sir? I have to direct them. With this case number, what you have done. My question has a relevance. The Tahsildar is a very good friend of the petitioner. The petitioner goes there, meets him, exchanges greetings, tells him that you delete my Jabardakhal note.
Because
so that is not done.
Please, kindly see page 21.
Case number.
ନାଇଁ ମୁଁ କହୁଛି
So you page 21, which is the case number you tell me, I'll ask Mr. Mohanty.
21 is
So you can save time.
କୋଉଟା ନାଇଁ ମ
Represent place.
Representation ହେଇପାରିବନି.
ନାଇଁ ଆନେକ୍ସର 4 ନାଇଁ ମୁଁ କାହିଁ କହୁଛି ଆନେକ୍ସର 4ଟା କାହିଁ ଦେଖନ୍ତୁ ତାପରେ
ମୁଁ ଆପଣଙ୍କ ଆଗରୁ ଦେଖୁଛି.
କହିଲେ ସେ
ମୁଁ ଆପଣଙ୍କୁ କହୁନି ଆପଣ ଦେଖନ୍ତୁ ବୋଲି.
ନୋଟିଫିକେସନ ରେଭିନ୍ୟୁ ଡିପାର୍ଟମେଣ୍ଟ
ସାର୍ ଯୋଉଟା ରେକର୍ଡ ନାହିଁ ମତେ ବଢାନ୍ତୁନି.
ଅଛି ରେକର୍ଡ ମୁଁ ଦେଇଛି
କୋଉ ପେଜରେ ଆପଣ ରେଫର କରୁଛନ୍ତି?
ଏଟା ଆନେକ୍ସର 4
ଅଛି ସାର୍ ଆନେକ୍ସର 4 ରେ ନାହିଁ. ପେଜ 21 ଆପଣ ଆଉ ଗୋଟେ କଣ ଦେଖୁଛନ୍ତି? ତାହେଲେ ସାର୍ ଗୋଟେ ଖୋଲି ଦିଅନ୍ତୁ ସେଇଟା. ଯୋଉଟା ମୁଁ ଦେଖୁଛି ଆପଣ ଦେଖୁନାହାନ୍ତି ସେଇଟା. ସେଇଠି ମହାନ୍ତି ସେ ରାଇଟ୍ ଟାକୁ ଆସର୍ଟ କରନ୍ତୁ.
ସରି ମାନେ ଆନେକ୍ସର 23 ଏତେ ଲେଖି 23 ପେଜ 23
ଆନେକ୍ସର 23 ନାହିଁ ଆପଣ ଆନେକ୍ସର ସରିଗଲା 5 ରେ.
ନାଇଁ 5 ସେ
ତ ସେଥିପାଇଁ ମୁଁ ଆପଣଙ୍କୁ କହୁନଥିଲି ଆପଣ ଦେଖନ୍ତୁ ବୋଲି. You have also made Tripathi sir.
25 ସେ ଯୋଉ ପେଜ 25
Whatever sir you
ନାଇଁ ଏଥର ପାରା 1 ରେ ଇନ୍ ରେସ୍ପେକ୍ଟ କାଇଁ ଆଇ ଏମ୍ ରେଡି I am going to read that portion.
Sir ଆପଣ କିଛି ଆପଣଙ୍କର ଏଥିରେ
kindly see in respect of private lands there should not be any note.
Sir I don't need to be educated. ତହସିଲଦାର educated ହବା ଦରକାର. ମୁଁ ତହସିଲଦାର କଣ ହେଇପାରିବି କି? ଆପଣ କୋଉ କେସରେ କେସ୍ ଫାଇଲ କରିଛନ୍ତି ଯୋଉଟା କି ପେଣ୍ଡିଂ ଅଛି ଯୋଉଟା କି ମୁଁ ତାଙ୍କୁ କହିବି ମିଷ୍ଟର ମହାନ୍ତି ମିଷ୍ଟର ପଣ୍ଡା ଯେ ସେ ଇନଷ୍ଟ୍ରକ୍ସନ ନେବେ.
କେସ୍ ନମ୍ବରଟା କି ମୁଁ ଜାଣି
ତାହେଲେ ନାହିଁ ତ ଆପଣ ଆଉ କେମିତି କରିବେ?
ନେକ୍ସଟ ୱିକ୍
Sir you assert your right. This is the reason that things are being taken casually. ଜଣେ IDM ପାସ୍ କଲେଣି order 226 ରେ.
ମୋର କହିବା କଥା ଯୋଉ
ଯଦି ଗୋଟେ ପ୍ରୋଭିଜନ ଗୋଟେ କେସ୍ ଟେ ଫାଇଲ କରିଥାନ୍ତେ ଦେନ୍ ସୋ ଆଣ୍ଡ ସୋ ପ୍ରୋଭିଜନ ଅଛି କରେକ୍ସନ ତାଙ୍କର ରାଇଟ୍ ଅଛି ସର୍ଭେ ସେଟଲମେଣ୍ଟ ଆକ୍ଟ ରେ ହେଇପାରିବ. ତହସିଲଦାର is a revenue officer. He is guided by certain acts and rules ଅଛି. Manual ବି to certain extent it is executive instruction କରିବ. ଆପଣ ଗୋଟେ ଆପଣ PC ପିଟିସନ ଫାଇଲ କରିନାହାନ୍ତି ଆପଣ ଚିଠି ଲେଖୁଛନ୍ତି.
ନାଇଁ ଏକ୍ଜିକ୍ୟୁଟିଭ ଇନଷ୍ଟ୍ରକ୍ସନ ଦେଇଛୁ ମୁଁ ଫାଇଲ କରିଛି.
Mr. Bose is arguing material matter ସେଥିରେ କିଛି representation କରୁଛନ୍ତି disposal ପାଇଁ. So ଆପଣ ସେଇଗୁଡ଼ା କହିବେନି.
ମୁଁ ଆଜ୍ଞା କୋଉଦିନ କହିବି representation
ସେ ଜଣେ ଜଣଙ୍କ ପାଟିରୁ ବାହାରିଗଲା representation ସେଇଟା. It has happened actually.
ମୋର ପ୍ରେୟର ଯେ ମାଇ
ଆପଣ ଗୋଟେ ମିସକେସ୍ ଟେ କରିଥାନ୍ତେ ପ୍ରୋଭିଜନ ଦିଟା ଲେଖିଥାନ୍ତେ ତାପରେ ସିଏ
my learned senior doesn't take amiss. He should file a 15B application for the revenue authority.
Absolutely.
Commissioner.
Absolutely.
And by virtue of this notification, he will direct the Tahsildar.
Absolutely.
That is
Because my lord, once the pata is published, the Tahsildar has no power. He cannot touch it.
Sir, did I say that incorrectly or I said that correctly?
Your lordship said that.
Yes. Initially I said that the Tahsildarଙ୍କର ବି କ୍ଷମତା ଅଛି but you assert your right.
ନାଇଁ 47 ମାନୁଆଲ ରେ ଅଛି
ସେଇଟା what you file a case they have to work on it. ଆଉ ତାଙ୍କୁ ଦେଖା କରି କହିଲେ ଏ କଲେ ପ୍ଲିଜାଣ୍ଟ୍ରି ଏକ୍ସଚେଞ୍ଜ କଲେ ବା ତାଙ୍କୁ ପ୍ଲିଜ କଲେ କଣ ହବ କିଛି ହବନି. Yes, the learned counsel for the Mr. এটা କେତେ number 22 ହେଲା Mr. Suraj Mohanty for the petitioner, Mr. Devraj Mohanty AGA for the state, learned counsel for the petitioner submits. ଆପଣ ଏଟା pending ରଖିବ ନା ଫାଇଲ କରିବେ ଗୋଟେ ଏଟା pending ଥିବ. The learned counsel for the petitioner submits that he shall obtain instruction if the petitioners have approached the authority by moving any application under any particular provision for correction of the remark column. Correction of the entries made in the remark column 10 मध्ये in the ROR. According to the matter is adjourned, the petitioner shall have liberty to move the regular bench for listing of the matter.
Item 23.
May I please your lordship, my lord? My lord, I am DC, my lord.
Yes, please.
My lord, my demarcation case is pending before the Tahsildar Hinjli Court. My lord, praying for a direction to dispose of in Hon'Ble.
They obtain instruction, you move, so they will take some time to obtain instruction.
My lord, is in order stage, my lord.
Yes. Mr. Arupananda Goswami for the petitioner. Mr. D. Mohanty AGA for the state. The learned counsel, Mr. Goswami, being present in VC, addresses arguments. It is submitted that the petitioner raises a limited grievance to the extent that the demarcation case number 98 of 2024 is pending before the Tahsildar Hinjuli Court.
My loss.
Tahsildar Hinjuli Court. It is submitted that the matter has not progressed despite pendency for about a year. The learned AGA, upon advance copy served, appears and waives notice. The learned AGA shall obtain instructions from the concerned authority regarding pendency of the regarding reasons for pendency of the demarcations case 98 of 2024. And stop with it. I'm not going to stop with it. Stop. He shall also obtain instruction if there is no other legal impediment. The reasonable time that may be that may be taken to dispose of the pending demarcation case. Stuff. List as paid for 4 weeks time granted. The petitioner shall have liberty to move the regular assigned bench for listing of the matter.
Minus of most obliged.
Item 24.
Mr. Amit Prasad Bose for the petitioner.
My lord, may kindly see one. My lord, initially, a the private opposite party before your lordship, OP number 3, filed a revision case under section 15B of the Orissa Survey Settlement Act.
Just kindly one second. What are Bhoypara option granted? 15B, sir.
Yes.
The Board of Revenue may in any case direct.
Yes.
On application made within 1 year from the date of final publication under section 12B of the revision of the record of rights or any portion thereof, whether within the said period of 1 year or thereafter, but not so as to affect any order passed by the civil court under section 42. This is the provision. Yes.
15B application was filed. The 15B application was dismissed on 6/6/2025, page 30.
Okay.
Thereafter, my lord, a recall application was filed. That your lordship may kindly see at Annexure 5, page 25, petition to reopen the case.
Right.
It was dismissed on contest.
Recall was dismissed on contest.
No. Original 15B was dismissed on contest. He should have challenged that in the read petition.
Correct.
He filed a petition to reopen the case. My lord will see.
So your argument is that he is functus officio.
Yes. Your lordship may see section 41 of the Orissa Survey Settlement Act.
And there is no direction from the High Court.
No.
Because what is happening at times,
yes,
they simply come and take a direction that has filed a recall petition.
Then
lordship may direct him to dispose of.
No. Even if High Court directs, your lordship cannot confer jurisdiction on the court. And review is a creature of statute. Section 41 says clerical mistake. But suppose 0.05 decimal is prayed for, it has been made 0.005 decimal. Then it's a clerical mistake. Your lordship, the revisional court has the power to delete 10 and make it correct. But he cannot sit as a
notice. Yes, Mr. Ponda, you are here. Which
when I find my objection that you don't have the power, he says, no, I will proceed with the case. That order is challenged before your lordship. That is under Annexure 1.
So that reopening case is disposed of or pending?
No, it's pending.
Pending. So you filed IA for stay of that reopening.
Yes.
Mr. Bose. No. Bose for the petitioner, Mr. Mahanti.
Yes.
He cannot. Decision. Which one?
Yes.
That court cannot confer jurisdiction?
Yeah.
Larger bench. 7 or 9. It was a celebrated decision. A.R. Antule versus R.S. Knight. The Supreme Court directed to do certain things to a certain authority. It was argued by P.P. Rao that court could not have. He had this courage to argue that before the Supreme Court, but Supreme Court accepted. So it is a matter of discussion actually. Today, since so I'm not under pressure, so I'm more. Please don't think that I'm just testing anyone.
No. Let's because I will not.
So that it becomes more enjoyable for you.
When my lord.
All on a sudden I cannot recollect that.
This side.
We should
And
have
that side also. I have never seen your
I
lordship
could have
under
developed-
pressure.
We-
This
I
side
could have-
also your lordship must be the same. Yeah. This side, that side also same.
We wish that
All on a
this
sudden I
privilege should
cannot
come
recollect that.
first of all.
And
Yeah.
my learned senior friend, Mr. Mahandi, is well up to date with all the data.
Yes, always.
Just I am not.
I'll take notice to OP number 3 only.
Is submitted by the learned counsel for the petitioner that the petitioner had filed a petition under section 15B.
OP number 3 had filed.
OP number 3 had filed
Settlement revision case number 160 of 24.
settlement revision case number 160 of 2024.
Dispose upon 6/6/25.
Under section 15 into bracket small b of the Odisha Survey Settlement Act, 1958. The said case was disposed of
6/6/25.
by order dated 6/6/2025. Thereafter, the recall ta ki file kala?
Recall he himself filed.
Thereafter, the OP number 3 himself filed a petition before the self-same authority
On 2/7/25.
on 2/7/2025 to recall the earlier order passed by 15B.
The last line of the order 15.
It is submitted that by the said order passed under section 15B, the case was dismissed.
Not dismissed.
Drop.
The case was dropped.
Unless the petitioner carries
Drop.
out the order passed by the
Drop.
civil court,
The case
will
was
discuss no. That is-
Drop.
Yeah.
The court is no way to
However,
proceed further.
however,
Not dismissed.
the authority exceeded its jurisdiction in proceeding in the matter to recall the order, and the case is pending before the authority. Same number, same name,
Same.
same number also.
Same number.
He submitted that after passing of the order under section 15B, which was under contest, being contested by the petitioner, the authority became functus officio. Clear? And he could not have proceeded further in the matter. But it is further submitted that it is nobody's case before the authority that the order under section 15B was subsequently challenged before any higher forum, or there was any order for reconsideration of the matter. You should notice along with this order.
Lordship, see that last part of that. It can be page 14.
Code 0.
14.
My learned senior want to say that
That is,
hence the
petitioner
claim the petitioner is not entertained at this stage,
because
hence drop.
due to the civil court in case number offense.
Rightly, wrongly, my lord, he has-
What he is saying is also in your favor.
Yes. That even if he drops it, he cannot reopen it.
Could not have. Could not. Unless directed by the superior authority.
I'll verify that.
Along this order, requisites for Mr. Lord AGA being upon advance copy served appears on behalf of the opposite parties 1 and 2.
1
and 2 waives notice. You require any extra copy?
No.
OP number 3.
I take more notice to open.
Notice to OP number 3 by SPW registered post with AD. Stop. Requisites for issuance of notice be filed within 5 working days. Pro forma parties were not taking notice.
No, they are opposite parties then.
Within 5 working days, and the returnable date be fixed. For the present, the learned counsel, it is submitted by the petitioner, learned counsel for the petitioner, that no notice be issued to the pro forma opposite parties 4 TO2 7, who are the opposite parties in the proceeding before the revenue authority. This after is liberty to the stop. The petitioner shall have liberty to move the assigned bench for listing of the matter. Regular assigned bench for listing of the matter. Yes.
There's an IE for
IA 17384 of 2025. Issue notice as above. The learned AG accepts accepts notice and appears on behalf of the opposite parties 1 and 2. Notice be issued to the OP number 3 by SPW registered post with AD along with the writ petition.
May I?
Yes, please. Yes. Along with the writ petition, one set of postal requisites and process fees shall be accepted. In the interim, it is directed that the further proceeding in the reopened settlement revision case number 160 of 2024, reopened by order dated 12/7/2025 shall remain stayed until further orders. The petitioner shall have the parties shall have liberty to move the assigned bench for listing of the matter.
The revision case is pending for the additional consultation.
সেটা দেখিয়ে লিখে দেবে রিভিশনাল কেস जो लिख लेने कि 160 हमको pending before the additional commissioner consultation and settlement Borgor. Just ठीक है लिखिए. Yes, next.
Item 25.
Password code. Yes, please. Ashok, Ago question. You are Mr. Panigrahi. So HK Sahoo. So HK Sahoo for the petitioner. Mr. D. Mahanti, AG for the state. Yes, Mr. Sahoo.
My lord, this matter is regarding the mutation case is pending before the Tahsildar Nimapada since 2023.
It is submitted by the learned counsel for the petitioner that the petitioner raises a limited grievance regarding long pendency of the mutation case number so and so before so and so. Mutation proceeding number 3366 of 2023 and 3367 of 2023 before the Tahsildar Nimapada. Opposite party number गोपनाथ निमापड़ा आगे आपण पार्टी करना चाहिए आपण गोप तहसीलदार करछन तहसील ओपी नंबर 4 प्राइवेट अपोजिट पार्टी कौन आपण को सेलर ना
भाई
ब्रदर
आगे
the learned AG appears upon advance copy served appears and waits notice on behalf of opposite parties 1 TO2 4. He shall obtain instruction from the OP number 4 regarding the reasons for pendency long pendency of the mutation case. Stop. He shall also obtain instruction if there is no other legal impediment. The reasonable time within which the mutation case can be completed. Issue notice to the OP number 5 by SPW registered post with AD. Requisites for issuance of notice be filed within 5 working days. As paid for 4 weeks time granted to the state to obtain instruction. The petitioner shall have liberty to move the regular asset bench for listing of the matter. The suit pending अछि केमती हबो म्यूटेशन दही परियो
suit
appeal हेतो तापर
नहीं अपील किछि
एतरे आपण केमती कहिबे कि जितले कि हारले आपण either of the party may go. Next matter. Yes.
26.
My guideline. Page 10, your lordship's order. Page 10 of the bill.
See, he's the opposite party present. Proper party. So Viren Shankar Tripathi for the petitioner. Mr.
Both tips.
Say duty no puri. The petitioner alleges hard letter counsel for the petitioner. The petitioner has alleged non-compliance of the order dated 24/12/2024, passed in WPC number 30822 of 2024. It is submitted by the learned counsel that the opposite party is the present incumbent, general manager, in charge Odisha Cooperative Housing Corporation. Para. Issue notice to the opposite party through court process as well as by speed registered post with heading. Requisites for issuance of notice be filed within 7 working days. The opposite party shall file show cause oblique compliance affidavit indicating compliance of the order passed by this court. List after the 4 weeks. Returnable date defective. Early returnable date be fixed. List after SR. Liberty to mention. Yes, next.
Copy of the content.
Acha. The Lord AGA request for a copy of the. ସେ ଆପଣଙ୍କର କୋଅପରେଟିଭ ଗୋଟେ କଣ କର୍ପୋରେସନ ଗୋଟେ ଆପଣ ନୁହନ୍ତି ନା ଦିଅନ୍ତୁ
ଅଛି ଅର୍ଡର ତ ଅଛି ଓ
ଷ୍ଟେଟ କୁ
ମିଷ୍ଟର VS ତ୍ରିପାଠୀ and AGA
ସେଇଟା ଆପଣଙ୍କର ଆମେ ଡାକି ଦଉଛୁ ବଟ୍ ସେଇଟା ଆପଣ ଆପିୟର କରୁନାହାନ୍ତି ଏଇଠି କଥା yes next
27
I beg your pardon. I'm in VC, my lord.
Yes, please.
My lord, it is a first contempt case for non-compliance of your lordship's interim order. And my humble submission with your lordship for issuance of a notice to the opposite party.
But I have instruction to appear on behalf of the contemptor, my lord. Let him serve a copy of the contempt and I shall take instruction.
ସେ କହୁଛନ୍ତି ଗୋଟେ କପି ସର୍ଭ କରନ୍ତୁ.
Yes, my lord, I will do that.
Mr. CONTC 3676 of 2025, Mr. Ramesh Chandra Naik for the petitioner. The learned counsel for the petitioner being present in VC addresses arguments. The petitioner alleges non-compliance of the interim order dated. In other matters, Mr. Swai, actually they have complied in this sense since it is an interim order. So
perhaps
actually it doesn't make any difference, but they are agreeing.
Yes.
So why you are precipitating a matter? Because in case they lose, they will have to pay the money. This is deduction of commuted value of pension. So they will be getting the pension. You have all the opportunity to deduct the money. So why you are not complying the order?
Perhaps recovery hasn't stopped. I will take instruction.
So your strategy should be, because they don't insist that because they will not pay. I also discussed with Mr. Naik earlier that this kind of order doesn't help the petitioner because bank is a big entity. But they may have to pay the amount once they lose in Supreme Court or High Court. Alleges non-compliance of order dated so and so passed in interim order. Read the tole achi. WPC number 22936 of 2024. Mr. Swami, you have not appeared in the writ petition?
No.
So Manoj Mr. Senior Advocate is there.
Yes.
It is submitted by Mr. Swami, who is present in court. Mr. Siddharth. Sorry, upon first one nata.
Vibhuti Bhushan.
Mr. BB Swami. Mr. Vibhuti Bhushan, sorry. Vibhuti Bhushan Swami. Another counsel is present in court and submits that he has instructions to appear. He further submits a copy of the petition may be provided to him to enable him to obtain instruction regarding compliance of the interim order. ଆପଣ କେବେ ଦେଇପାରିବେ Mr. Naik?
Madam, within 2 days I will give.
The copy of the petition shall be served on Mr. Swain within 3 working days to enable instruction. The matter is urgent by 4 weeks, 2 weeks.
2 weeks, my lord.
Urgent by 4 weeks.
Lord, only one submission I have, my lord.
Yes.
Union Bank has role to play. There is a main contested bank. So Union Bank may be deleted and let them contest.
Commented by Mr. Have they made Union of India party?
Yes. 1 and 2 they have made. In read petition, not in court.
नहीं रीट से प्लेस करूना
अच्छा thank you.
पार्टी को आपण को पार्टी करी ना यूनियन इज नॉट मेड ए पार्टी इन द कंटेम्प्ट
ना कंटेम्प्ट रे पक्ष नो खाली रीट रे
yes I am not touching रीट पिटिशन
obligation.
So Mr. Swai, if you stop deducting that, if they lose, you take the entire amount because they are your employees. You are having the entire money with you. Yes. They are your employees and they are old persons. Only. Yes, the liberty to mention. Next.
Item 28.
28 रे गोटे रिपोर्ट मगा हैतला regarding condition of the ये but it has कहीं आसी नहीं से रिपोर्ट टा it पूरा मैटर.
I have called ISC, consult ISC. Due to
the matter has been listed. The matter was disposed of by order dated 11/7/2025. No, 11/12/2023.
In fact,
directing the superintendent of police and SDPO.
Let's say report on the basis of order dated 9/12.
11/12, not 9/12, 11/12.
Is not order is
9/11 rather. Sorry, 9/11.
9/11.
What लिखना?
Format is appearing.
9/11/2023. Stop कर दे back comma करिए. However, comma. The direction was issued to the superintendent of police of the को जगह से था Balasur, as well as the concerned SDPO to furnish a report regarding welfare of the victim. The matter has been adjourned and listed again. The matter was listed again on 28/11/2023, 11/12/2023, 11/7/2025. The Learned AGA submits that he has not received instruction and may be granted further time. Is directed if the instructions are not provided, the officer concerned shall remain present in person to assist and apprise the court on the next date. List when this bench functions next.
I'll take instruction because.
But it is 2 years now.
That is because I have given a letter.
Yes. No further coercive orders are passed against the opposite parties for not responding to the court's order being persuaded by the Learned AG, who assures that he shall obtain instruction in the. One thing you can do, sir, after you receive the instruction, you simply mention it so that this because it is again and again listed.
Yes.
This disposed of since 2 years. Yes, next.
Item 30.
Item 29.
Same adjourn kale.
Should not have. In my absence, without intimating, should not have.
Oh.
And second thing, he has got no locus standi. He is the co-accused with the petitioner in another InfoCity PS case number 36/25. So it cannot appear. And moreover, the main case is disposed of. And I have filed the present application which is independent in nature, where notice has not been issued. Your Lordship has not yet directed to register a case. After registration of the case, before registration of the case, the accused or anyone doesn't have a power to do. He has got no locus standi to ask for adjournment.
No, this Sonia Tripathi is not the party.
Sonia Tripathi the accused, and your Lordship has not yet issued notice or directed to I mean, registered FIR on my this application.
No, but it was said on behalf of Mr. Arun Kumar Acharya.
No, Arun Kumar Acharya is no more appearing in the case.
But it was said that he's appearing. Se kahile se appear କରୁଛନ୍ତି.
କହିବା କଥା ନୁହେଁ ମିଛ କହିଲେ again that should not have been.
Some other
your lordship should have asked him to wait till I arrive, till the turn comes. The whole point.
So which is the IA? Which is the IA?
IA 19 of 25. This is to initiate a proceeding under section 340 for filing false affidavit and misleading the honorable court.
Acha se jo 19 re.
Yes.
Already the complaint case has been taken up.
That is different issue.
No, it's not the same affidavit.
No.
The
matter
independent.
That is the accusation is different. More or less with the same thing. Reference is there, but it is different. That
no, I mean in 19.
I 19. I filed this Milord to initiate a 340 proceeding against the petitioner, the main petitioner which has been withdrawn, as well as the deponent of that petition. And they have made a mockery of this court. They have made this court to be less than a Tahsildar. 10 to 12 340 petitions are filed. I
will kindly check IA's flag H.
Flag H is what is
it? Dated filed on 6th of January 25. देखिए date टा मेरा मोरे number टा देखो
6th of January
number टा देखो नहीं
9 तक
19 sir.
Modification, that is modification of the order.
19.
Yes, no. 19 is the initiation of 340.
You are now referring to 9 or 19?
I am 19.
19, yes. 19.
19. He has got no locus standi. It's an independent proceeding. He has got no locus standi to ask for adjournment.
You want to say
and moreover,
19 you are saying no notice has never been issued.
No, this is what your lordship has to pass order. The first time it has come.
IA number 19 of 2025. सेटा कि नेइतले जो फर्स्ट मैटर था सेटा तो तांका साइड रे आड हो
and another thing say dispose of the bail petition है 7177 that is disposed of withdrawn and that accused Sonia Tripathi Mr. Acharya with all respect he has been made co-accused in another case he cannot also appear as a lawyer for the another accused
he has been
implicated as an accused
who
Mr. Acharya FIR has been registered where Mr. Sonia Tripathi, Mrs. Sonia Tripathi and Mr. Acharya are accused. That case is pending, that is filed InfoCity PS case number 36 of 25. Otherwise also he cannot appear because he is a co-accused.
When you said he, I could not follow actually. Maybe they will have their own
that is legal barrier. That is legal barrier. Accused cannot appear for another co-accused as a lawyer. But this 19...
This is coming for the first time.
This is for the first time. किसी जो एक्शन न ने जहाँ मुश्किल है जाउची त माने ऐसा आवर कमिंग इज बिकमिंग एम्प्टी फॉर्मेलिटी कलेक्टिंग दी
पंगटा जो एड्रेस टा नोटिस नवा पे एड्रेस टा को पेज रे अछि
माने एड्रेस इज नॉट नेसेसरी accused persons are not needed to be heard before the FIR is registered. Here, this IA, they don't, under the law, they don't require, it is not necessary to issue notice.
But they should be heard because...
Should not be. This 340 doesn't say. And there are judgment to show that before, here 340 ballot, your lordship has to satisfy on materials available, whether the affidavits they have or this thing on my petition, they have filed false affidavit or misled this honorable court or not. But if necessary, your lordship can inquire. And in the inquiry also, the proposed accused has got no right to appear. Only when your lordship is satisfied and direct for registration of the case, then after issue...
This inquiry has to be done by?
By your lordship, by register, your lordship to whom the direct if necessary. But in view of our averment made in the petition with reference to the already the document existing in the bail petition, I don't think inquiry your lordship will require it. It's a case directly your lordship will direct the register to lodge a complaint before the authority. Because in one case this already been issued in another by a coordinate bench of this honorable court. And there are 10 to 12. In another case, before the fresh matter was filed, it was giving warning that if you are necessary, if you can file, there are a lot of false affidavit on record, and if you necessary, you can withdraw, or otherwise, by client will be forced to file 340 petition. And wide open in the eyes and ears, they pursued it. And in that case, there are 340 petitions are filed. One for the bad petition, second for the counter, again they have filed false affidavit, and second, again, third in the rejoinder affidavit. So this mockery is going on unless a serious exemplary punishment is given. They have made this High Court to be a, mockery. Your Lordship will verify one affidavit at least.
The authority is judicial.
Yes, your Lordship will directly, your Lordship, the authority is direct register judicial to.
Only 19 of 2025.
Register judicial to lodge the complaint. He has to lodge the complaint on the basis of my IA.
HS Misra for the petitioner. Petitioner in the petitioner informer.
Yes, ma'am.
Petitioner in the IA.
Ma'am, yeah, 19 of 25.
Yeah. But petitioner, Mr. Here, Mr. Mohanty, you are appearing, or Mr.
No,
Panda?
nobody can appear. This is
versus state.
State.
Mr. Devraj Mohanty, AGA for the state. It is stated, and in the petition supported by affidavit, that false affidavit has been filed in the proceeding, that is in the proceeding BLAPL 7177.
7177 of 24.
BLAPL 7177 of 2024. A further prayer is made that to initiate proceeding under section 340 of the CRPC, 1973, since repealed and substituted by Bharatiya Nagarika Suraksha Samhita. That is closed. The records of the said BLAPL and the present IA shall be placed before the registered judicial for conducting for verifying and for verifying the allegations made in the petition, and to furnish a report prima facie before this court for consideration. List after 3 weeks, liberty to mention. Mr. Misra, regarding
Yes, sir.
regarding
That's
Second round litigation, my lord. Non-compliance of your lordship for order dated 7/12. Non-compliance of your lordship for order dated 7/12.
So, Sunday, just to set the option.
No, every amendment କରିକି ବର୍ତ୍ତମାନ ହେଇଯାଇଛି.
Particular reason.
It's it Nahanti. Say Nahanti, what Mr. Mohanty is right.
Amendment petition on your lordship allowed, thereafter I have filed consolidated petition also. હું ଦେଇଛି.
Registry भूल करथिबे. What she is saying, जैसे देला परे.
I think so.
After
the cause list, it is brought to our notice by the learned counsel for the petitioner. It is
no,
Ms. Patnaik, Mr. T. Mohanty AG. BK Patnaik, Babita Kumari Patnaik. It is submitted by the learned counsel for the petitioner that though she has amended the cause title of the content petition, the same is not reflected in the cause list. The registry shall do the needful for correcting the cause list to bring on as well as the case brief by reflecting the up-to-date amended cause title.
Yes.
The learned AGA appears and on behalf of the opposite parties, they being the officials of the government, and seeks time to obtain instruction regarding compliance of the order. The first, second content सेमती किछि नाही तो?
Second content बहुत थोड़ा असलाणी इधर.
Second content.
इधर ଗୋଟେ similar situation version जोटा SLP ହେଇଥିଲା ସେଇଥିର ଲିଷ୍ଟ କରିଛନ୍ତି ଖାଲି ଦେଖି
I could not get you. SLP hele semane kouchon je SLP actually that's a valid.
After 4/4/2025 rule, sethre hela je pending applications to be considered are rules. Appointment under rehabilitation assistance scheme matter.
So dispose of you.
Seita hela pore
ए आपण त्याला content काय pursue କରୁଛନ୍ତି
content ko
ଆପଣଙ୍କ problem କଣ ହବ kindly listen more my proposition is different. If they are to consider, it will be considered not under the 24 rules, prior to 25 rules. It will be a consideration after. So what is the মানে ଆପଣ ଯଦି content pursue କରିବେ, suppose you are pursuing the content, the order was not under 25 rules, or it was
not.
So that is what I am asking you. So I have understood it correctly.
Already.
No,
Your lordship's direction already there.
No, lordship has not directed to consider under the 25 rule. Content can I cannot. Obviously, no, cannot be.
Your lordship.
There is a clear jurisprudence that contempt they will be punished. There cannot be any direction for consideration on merits. But you are rightly saying, and they also concede that after the SLPs were filed in the Supreme Court, government took a stand that we are amending and we will consider.
Number of cases.
So then how can this court insist that you consider under section earlier rule?
But your lordship's direction is to consider in accordance with 90 rule, my lord.
Not after SLP.
Not after. Prior to
after amendment. After amendment, this is a unexecutable order.
But they have
Past
not.
content ଆପଣ ଦେଖନ୍ତୁ ଆପଣ ଗୋଟେ non existent rule ରେ ଏଇଟା ଆପଣ contract act ରେ ପଢିଥିବେ supervening impossibility of implementing an order after amendment. How can we say now it is illegal order?
No, my lord. My case is 90 rule.
ହେଇପାରିବନି ଆଉ
90 rules.
ଆପଣଙ୍କର 25 rule amendment ହେଲା ପରେ
25
Supreme Court ରେ ଆପଣ ମାନେ concede କଲା ପରେ that you will allow consideration. High Court cannot review and say that you go back to 90 rule.
But 4/4/2025 rule says pending application considered as per 90 rule. 25 जो it.
There you are not correct.
Date of birth.
This bench has pronounced judgments. We have never said that. So government has taken a government wants to consider you. By the markings you have a grievance that for RA appointment the marking system you are not getting the benefit. Is it not? So that is how they are conceding. They say that we will apply the earlier criteria.
ସମସ୍ତେ କରିଦେଲେ ମୋରି କେସ୍ ରେ କେବଳ କରୁନା
ହବନି କାହିଁକି ଆପଣ କଣ୍ଟେଣ୍ଟ ପଛରେ ପଢୁଛନ୍ତି
ନାଇଁ ସବୁ ଜାଗାରେ ଏଇଟା ଯଦି କଣ୍ଟେମ୍ପ୍ଟ ରେ
ଶୁଣନ୍ତୁ
to give some times and consider my case.
No, that order I cannot pass. You file a memo that will be taken on record. You serve on him.
ତାହେଲେ ସେଇଟା ବି ମତେ
I cannot pass a vulnerable order. But I know if I pass that order in content that you consider in 2025, that's an illegal order. Several decisions. Supreme Court, High Court also is there.
Then ship may directed to consider my case.
Not in content, madam. ସେଇ ଜିନିଷଟା ମୁଁ ଆପଣଙ୍କୁ ସେତେବେଳେ ବୁଝଉଛି ଆପଣ ଗୋଟେ ମେମୋ ଫାଇଲ କରନ୍ତୁ ଫାଇଲ କରିକି ଦେଖନ୍ତୁ ଯେ ଯେହେତୁ ଏଟା 25 rules ରେ କନସିଡରେସନ ହବ ସେମାନଙ୍କୁ ଦେବେ ସେଟା
Let him file a IA. file.
ଆଇଏ ଆପଣ ସେ ରିଟ୍ରି ଫାଇଲ କରିଦିଅନ୍ତୁ ସେ ରିଟ୍ରି ଫାଇଲ କରନ୍ତୁ କଣ୍ଟେଣ୍ଟ ରେ କରନ୍ତୁ ନାହିଁ If you want, I will give you those decisions. One decision by this bench, by Justice Indrajit Mahanti and Justice Vishwajit Mahanti, they followed the Supreme Court decision that we cannot direct on merit. If they have committed contempt, then they are to be punished. But ଆପଣଙ୍କର problem ହେଲା ଯେ ଆପଣ କିଛି you are pursuing a litigation where you require a consideration under 25 rule. ଆପଣ ଆଇଏ ରେ ଯୋଉଟା content ରେ ଆଲେଜ କରୁଛନ୍ତି earlier rule. Since we have time, so I am discussing. So, but obviously you are not going to achieve anything. They will file show cause, saying that since 25 amendment has come, we are considering. We will consider. That's a possibility. They may file that show cause. But ଆପଣ ଯଦି ସେଇଟାକୁ proactively ଆପଣ ଏଟାକୁ ଗୋଟେ ଆଇଏ ଟେ ଫାଇଲ କରିବେ ତା ସାଙ୍ଗରେ ଲିଷ୍ଟ କରେଇ ଦେବେ ଡିସ୍ପୋଜ ହେଇଯିବ. Yes. Please.
Contempt is a form of execution and executing court cannot go behind.
Not execution, it is a punishment only.
Not punishment, but
ଆପଣଙ୍କର stand ହଉଛି you have executed. Content ରେ difference ହଉଛି just like satisfaction of the decree, you will say that you have complied with the order.
Another form of execution.
what's the attachment?
No, the decisions I can cite that so High Court or any court
Go behind it. The whatever order has been passed.
cannot pass direction on merit.
Yes, that is there.
It is not a civil court, but as far as content is concerned, we will say that you have not complied. But now the petitioner has a problem because the rule gets amended, it was accepted by the Supreme Court and High Court also.
Seek further direction. They cannot.
So that you are not withdrawing it. Suppose you may say that the petitioner's case is pending. But after you file the IA order is there, it can be disposed of. Yes. It is submitted by the learned counsel for the petitioner that the order passed by the corrected cost title the petitioner in the petition alleges non-compliance of the order dated 7/12/2021 passed in WPC number 37144 of 2021. It is submitted by learned AGA that in the meanwhile, the OCS Rehabilitation Assistance Rules, OCS RA rules so and so has been amended with effect from date 1/4/2025. 4/4/2025. And accordingly, the petitioner's case can be considered. So that will help you. Can be considered in the as per the amended rule. Para. The learned counsel for the petitioners seeks further time to obtain instruction and do the needful. It is submitted by the learned counsel, Ms. Patnaik, that if so advised, the petitioner may file an IA in the disposed of writ application. As paid for, the matter is adjourned by 3 weeks or 4 weeks. 3 weeks. Liberty to mention. And you filed that memo for listing with the content. Mr. Misra.
31.
Level 9 quotation notice has already been issued.
I have filed so.
Complied.
2 to 4. Yes.
Mr. Manojan Misra for the petitioner. Mr. Let him go through. Let him go through that. You have a copy. Mr. Mahanti. Mr. D. Mahanti, AGA for the opposite parties. The learned AGA submits that the show cause on behalf of the opposite parties has been filed. Stop. The learned counsel, for the petitioner submits that he may be provided with a copy of the show cause to enable him to obtain instruction.
Yes, sir.
The show cause copy, along with all the enclosures, shall be served on Mr. Misra within 3 working days. Within 3 working days. List after 3 weeks, liberty to mention.
No, sir.
Mr. Gupta.
When the second contempt is issued on 25/1/2024, 1 year, 9
Mr.
months.
Jyotirmoy Gupta for the petitioner.
And
Mr. Devraj Mahanti for the opposite parties. The learned AGA submits that he may be granted further time to obtain instruction regarding compliance.
Record to change.
Sorry, sir.
First title. Has to be
changing.
Satyanarayan Sao.
It is submitted by the learned counsel for the petitioner. Gupta it is submitted by the learned counsel for the petitioner that he shall bring on record the present incumbents who are holding the posts, designated post as
Director of Secondary. Director of
who
Secondary.
is, not a plural no, who is holding a post of Director Secretary Education. Stop. Accordingly, liberty is granted to file amended consolidated cost item, bringing on record the current incumbent as opposite party. The learned AG shall also obtain instruction regarding compliance of the order. But whoever is there, it can be disposed of.
Yes.
Yes.
21 meter.
Nah.
At least after 3 weeks, liberty to mention.
Obligation.
There consideration pen thila.
Considers.
Rehabilitation assessment na kon?
Area
different.
Considers.
Se आपण ताकू जहाँ भी करूँ तो so that ताकू जनेले से challenge करिवे जदि आपण रिजेक्ट करिवे जदि देले से जहाँ भी पाइबे जदि satisfied भला कथा नले
21 method 2021 method.
Okay.
Next.
तो पास में रुड़ा डाकी दियो.
Let's say some
page
Rajas.
This honorable court is not. Let's say some list. Maybe listed for your last sitting. Your lordship's last
तो डेट में जानने होता तो रेगुलर बेंच ना आका नहीं मुझे तो लिबर्टी टू मेंशन कोई
Alright.
I'll take a step.
Pastor item 6.
आपण जेतबे टाइड अप मैटर रो दोचोती मेमो उडाको सोडा का कलेक्ट हेकी रहूची जेबे मु बसुची सेबान सेटा को आनुचंदी मते आजि कहितले 9-10 टा अछि बोली आई डोंट नो हाउ मेनी टाइड अप मैटर्स मते बोले एटलीस्ट 9 टा कि 10 टा मैटर अछि तो आपण मैटर सेतिर गोटू 6 में लिखि देबे नॉन अपीयर्स फॉर द पिटिशनर दो द मैटर इज कॉल्ड ट्वाइस ओवर 6 रे की अछन प्रेम पिटी मंती एसी Petitioner none appears for the petitioner, though the matter is called twice over. To grant further opportunity, the matter is adjourned. The petitioner shall have liberty to move the regular assignments for listing of the matter.
Item 9.
I on behalf of Mr. Shivasankar Chaini, I pray for one adjournment, your lordship.
ठीक अच्छी 9 ने लिखो तो मिस्टर शिवशंकर चौनी मिस्टर
Ellen Rohit Singh.
अच्छा मिस्टर लक्ष्मी नारायण रोहित सिंह फॉर मिस्टर चौनी
Yes.
Mrs. Chayni for the Ellen Rohit Singh for the you are writing RAT Singh.
RAYAT. Yes, I am.
RAYAT.
Yes, your lordship.
Arjuna Rohit Singh RAT लिखचन
Say Rat Singh. RAT. Yes, I am.
RAYAT. Mr. Ellen RAYAT Singh on behalf of SS Chayni for the petitioner. Adjournment is sought for on behalf of the petitioner. Accordingly, the matter is adjourned. The petitioner shall have liberty to move the assigned bench for listing of the matter.
Item 10.
The last question, your lordship directed to comment.
Can we come after 5 minutes? I'll just have a walk and.
For them ready, but could not file. I have yesterday said that it is filed. Yes.
Okay. 31 तक की नहीं थी ना? अपन ऐसे था it is submitted by the learned AG correction कर lecture है ना that he has obtained instruction and
file
so cause shall be filed within
within
7 working days. The copy of the SOCOS shall be served on the learned counsel Mr. Misra. अपन ने Mr. Misra को inform कर दे. So sir कौन लिखी Mr. Misra for the petitioner to enable him to obtain instruction on the same plan. तापर लिखिए list after 4 weeks 3 weeks or 4 weeks कर देना गोटे भी गार्ड करते हैं. Yes, Mr. Pagan.
May I please lordship?
Yes, please.
Madam, last was your
item the कितने I have lost track actually. कितने item?
Item 10 by
10 yes. Item 10 लिखो तो Mr. Mrityunjay Pagan for the अच्छा इतने तो कौन सुरेंद्र कुमार साहू है?
On behalf of Mr. Sahu.
अच्छा Mr. Mrityunjay Pagan on behalf of SK Sahu for the petitioner Mr. Prem Kumar. Yes.
2 weeks time may be granted to file counter. Instruction has come, I will file this by.
The Mr. Pagal refers to the earlier orders passed by this court. Just give me a moment. Dated 21/7/2025 to submit that the instructions are to be provided by state. The learned additional standing counsel 6 for the time. As prayed for, submits that he has received instructions and shall file affidavit. As prayed for further 3 weeks time granted?
3 weeks time.
Granted. The affidavit shall be served on the learned counsel for the petitioner to enable him to obtain instructions from the petitioner and file their response, if any. List after 3 weeks, liberty to mention for listing before the assigned bench. The regular assigned bench. Yes. Whether tied up matter, no. But why these matters are kept pending?
covered matter.
Covered matter. Whatever, but a bench re kahinki tago list hi paruni. Dimas 3 mas padi ki roz. Yes, ठीक. Next.
48.
लिखी हुई है जैसे जोड़ा नॉन अपेयर फॉर द petitioner दो मैटर इज कॉल्ड ट्वाइस होगा तापरे 14 ने की अछंती गवर्नमेंट काउंसिल 14 मिस्टर एसबी पढ़ो liberty to mention on listing before the regular assignment. Petitioner shall have liberty to mention for listing before the regular assignment. 15 Mr. Swai, Mr. Swai for the petitioner. Mr. SB Panda AGA for the state.
Yeah, the petitioner has purchased one piece of land from the title owner and filed a mutation. If mutation is rejected, the imposed order on the index of 5, your lordship can see.
Mutation appeal re jantu.
Your lordship, what happened? There is a
read petition re what limitation achi. When there is a factual adjudication by the revenue authority or a suit or whatever, read petition is not a efficacious remedy.
The observation is that this property is been seized by the EOW in EOW case case number 3/13.
You have been duped by the.
Because that will not be argued in the appeal. That is the issue.
It has to be. It will be.
The appeal pending, but there is
mutation appeal is the best forum for you.
But see, actually, I have purchased one piece of land from the plot number 5.
So, what is the principle of this purchase? What is the principle of purchase? You see, I'm not scaring you or finding any fault with you. You cannot have a better title than your predecessor in interest.
Yes, ma'am.
Correct. Whatever title he had, you cannot improve that by purchase. He cannot sell it a better title than he is holding. That's the first principle. Second principle, if it has been seized or the subject matter of any litigation, you are a lease pendant purchaser, you don't improve your title.
Actually, it is not been seized because I have purchased back plot.
So now you are supporting me in my legal proposition, not as a counsel, but the supporting the judge in legal proposition that you go for mutation appeal so that it will be at least adjudicated by the authority that this is not the property. The mistake committed factually by a registering authority. One thing. Second thing, mistake committed factually by the mutation authority. It may be now it has been given power to RI and also Tahsildar. So that can be corrected by the appellate authority, not by the writ court.
Appellate authority, but the observation is against me because the EOW case.
Obviously, sir, he may be scared. He doesn't know that for him the job is at stake. You have to move the appellate authority. How can the writ court say that this is not a EOW, this has not been seized by the property?
Instruction.
So you have to do that. Always assert your right in a proper manner.
With that report will not submit.
You want disposal?
If with that report that I will raise that point that the EOW case is not pending because the appellate authority. Until the EOW
Yes,
case
because you see the Tahsildar becomes functus officio. He cannot recall that order. This exact point has been argued today by Mr. Bose.
Yes, please.
So you have to move the appellate authority. In other matter, Mr. Mohanty's matter, 15B application has never been moved.
Yes, sir.
15B, there can be a direction also. But since it is only a mutation, you can move the mutation appeal. Co-provision kontu. It is expected from you, from Mr. Swine. You should be ready with all the case, Bear Act, everything. You have spent sufficient time at bar now. Mutation provision कौन mutation appeal provision कौन revision तो ठीक है जी 15B तो
mutation appeal is
12A, 12A. Sub collector पाखर ना कोटा
mutation manual.
वो mention करूनी because it may be a mistake also. Because my style of understanding is that I have to be sure and doubly sure. Whenever I appear before the court, I check, recheck. So I am not myself sure. Mutation टा को provision में আছে?
It is in mutation manual below.
Manual टा একটা executive instruction. সেটা actually mutation manual only records what is there in the statute. কিন্তু সেটা ଗୋଟେ মানে over a period of time as if mutation manual is the statute, it's not a statute. Just give me a moment. I'll assist you.
No, sir.
No, definitely. You no difficulty. Don't take it personally. तो देखिए कह देबे अपन.
34 is the provision for mutation. The correction of error.
34. Pursuant to a sale deed also 34.
Yes. Registering authority no correction is equal. 34 टी लॉर्डशिप में कहीं have a query.
Can appeal to 12 एर अछि. Survey settlement अपन रेफर करछन.
हाँ, survey settlement.
34.
लॉर्डशिप में can have a glance. Contingency.
Section 3, subsection 3, section 6.
Registering authority instruction letter. When a sale is registered, intimation goes to the Tahsildar for mutation, and Tahsildar is bound by that as per 34.
तार अगेंस्ट अपील टा?
Yes, particularly.
सब collector पर अपील हुआ ना?
सब collector पर यार अच्छा mutation अपील टा पारा 92 रे हुए से. 42 रे mutation manual 42 yes. Read with 42. That emanates from 42.
41, 42. Kindly read. बही आ बही नहीं. आगे गोटे आंसर दी.
आगे आई थिंक पढ़ो.
सर्वे सेटलमेंट ता देचंती.
आगे ऑप्शन.
आपण कोटा धरछन मिस्टर स्वाई. सर्वे सेटलमेंट एंड म्यूटेशन.
Survey settlement.
हां देखो 41.
Manner of disposal of mutation application.
Yes.
The mutation application and petitions of objection, if any, shall be disposed of after giving the parties an opportunity of being heard and inquiry to be held, shall be summary in nature.
Summary in nature. So not a summary proceeding, but it is an opportunity. In fact, today we discussed that.
Yes.
That since it requires Mr. Patnaik's matter, that it requires hearing of the parties, so no notice to be given 6 months time. Budan matter. This is the 41. Yes.
Provided that when all co-sharers or recorded tenants sell the plot part or in full, the mutation application shall be disposed of or without hearing or in full. The mutation application shall be disposed of or without hearing of the parties and further without holding the field inquiry, so that disposal of such mutation case is ensured within a week.
Then appeal?
Then appeal. An appeal from any final order made under the Rule 41 shall lie if the original order was made by an assistant settlement officer exercising the powers of Tahsildar under those rules and working under the administrative control of the settlement officer to the settlement officer.
Yes.
If the original order was made by any other officer exercising the power of the Tahsildar under this rule, the sub-collector officer.
Sub-divisional.
Sub-divisional.
Sub-divisional officer is sub-collector.
Yes,
sub-collector comes sub-divisional officer.
Yes.
SDM. So 42. Mr. Nikhil, appearance section. It is submitted by the learned counsel for the petitioner that the petitioner is agreed by the rejection of mutation by order dated 19/6/2025, passed by the additional Tahsildar Bhubaneswar in mutation case number. देखिए अपन लिखिए भूल जल्दी mutation case number 6827 of 2025, which was initiated as directed by the by a coordinate bench in order dated dash
In order that
passed in WPC number 13987 of 2025.
16/5/2025.
16/5/25 in WPC number 13987 of 2025. जो रिजेक्शन ऑर्डर आपण लिखलेनी सेटा आपण भूल देखली सेटा 17/7/2025 17/7/2025 initiated date is 19/6. He submitted that the additional tahsildar committed error of fact in as much as he has wrongly recorded certain facts with regard to the property being seized by EOW of CIDCB Odisha.
No, EOW crime branch Bhubaneswar.
Helani, crime branch is CIDCB. It is commonly called EOW of CIDCB Odisha.
PS case number 3 of 2013.
Champion do seda. The wrong submission that question apna details dakar no. The learned AG in response submits that the petitioner has a more efficacious remedy in as much as the order impugned suffers from factual error as alleged.
Another ground was there.
Sorry?
Another ground was there. Objection. One is that the vendor who has sold the property to me, he has got the property on lease.
Lease on land छेड़ी पड़ी.
Lease on land. But
सेटा तो हबनी प्रकृतर.
किंतु ताना
सेटा अपन लीज ता अपन जदि फ्री होल्ड हबो ताले म्यूटेशन हबो. जदि अपन लेसर थ्रू आनिबे परमिशन ताले हबो.
तारा record of right ताना issue is record of
right doesn't confer any right title interest flat Supreme Court decision which it neither confers nor improves any title. It has to be a sale deed only. Deed of conveyance. Transfer of property act जो Para. The AG refers to sections rule 41 and 42 of the Odisha Survey Settlement Rules 1962. For convenience of reference, the said rules are reproduced herein. Para. It is submitted by the learned counsel for the petitioner that he shall approach the appropriate appellate authority under the Odisha Survey Settlement Rules 1962, read with Odisha Mutation Manual, 1962 for redressal of his grievances. Para. Having heard learned counsel for the petitioner and the learned AG, the writ petition is disposed of, granting liberty to the petitioner to move the appropriate authority under the Odisha Survey Settlement Rules 1962, read with Odisha Mutation Manual 1962 for challenging the order dated 17/7/2025 passed by the additional tahsildar in mutation case number dash. If appropriate appeal is filed within a period of 4 weeks, the same shall be considered by the appellate authority after giving due opportunity of hearing to the petitioner as well as all other concerned. But it is expected that the appellate authority shall deal with the matter expeditiously, preferably within a period of 6 months from date of communication, from date of filing of the appeal, along with copy of this order. The 2 years will be. You are not present. I was citing a case where it is pending since last 20 years or more than that.
17.
Same order. Dithara jo call rechi. 17 ne kiye government council kiye achanti? Mr. Ponda, SP from.
18.
In this matter, my lord, the limited prayer of the petitioner is that
Mr. Raj Singh, on behalf of SK Sahoo for the petitioner, Mr. SB Ponda AGA for the state. Yes.
My limited prayer is that, my lord, annexure 4, page 16 is pending before the opposite party number 3. My representation. That may be considered because 111 kV.
Se to amos nahanti na ama agare. How can I direct in their absence? Upon jodi taku copy serve karibe anu nahanti. In these kind of matters, what you can do that you serve a copy on the regular council. Maharana Mr. Das, Mr. Ponda cannot take instruction.
Yes, I'm sorry. Or else you put also direct. I can.
No notice nahi onto.
Notice.
SB Ponda for OP 1 and 2. Hela.
3-4 notice.
How tell ठीक अछि. It is submitted by the learned counsel, Mr. Raj Singh, that the representation of the petitioner dated 27/5/2025 enclosed to the writ petition marked as Annexure 4 is pending, which is regarding shifting of 11 kV tower. 11 kV is a huge Herculean task.
Life
The
is in
shifting
danger,
is not that easy.
but our life is in danger.
I understand. In fact, I have experience of as a administrative judge of a particular district, to be precise, Fulbani, where there was a 11 kV line on the land for district court pending before the 11 shifting of a tower which carries conductor of 11 kV. It is submitted that despite the representation, the authorities are not taking up the matter. Issue notice along with this order. The learned AG, upon advance copy served, appears and accepts and waives notice on behalf of the opposite parties 1 and 2. Notice to OP number 3 and 4 by speed W registered post with AD. With requisites for issuance of notice be filed within 5 working days. List after SR. Petitioner shall have liberty to move the regular bench for listing of the matter. Yes. Next.
Item 20.
Yes. Mr. Alok Kumar Ponda for the petitioner. Mr. SB Ponda. Mr. SB Ponda for the AGA for the state. Yes, Mr. Ponda.
My application for mutation was rejected only on the ground that the will has not been probated. Though in the district of Balangir, probate of a will is not required. And
so why you are not moving the appellate authority?
My lord, to that
because factual assertion, always the appeal
it
court
has already been decided by this honorable court in Catena judgment.
So it is binding on the sub-collector.
If you losses,
you same order as in.
I am relying
upon. Add for
I am relying upon.
Actual dispute nahi ki. Order upon kala. Kitra matter. So Saubhagya Swayam, item 15. It is submitted by Mr. Ponda that for the district of Balangir.
It's in respect of Subarnapur, which is carved out from the Balangir district in 1993.
That is correct. And submitted by the learned counsel for the petitioner that regarding probate of will, it has been decided by this court, by the High Court in.
I am relying two judgments.
Judgments in writ petition decided on so they make copy down. Pencil.
In the second,
the principle of probate is not applicable for the district of Balangir. Stop. Since Subarnapur is a district carved out from the Balangir district, the same principles shall also apply. They submitted that the petitioner shall approach the appellate authority under the Survey Settlement Act 1962, read with the Mutation Manual 1962 for redressal of his by filing appeal against order dated
15/4/2025 and 24/4/2025. That is page
24/4/25 now. Page 23
page, my lord, it starts from page 22.
Last order now.
Last portion. 15/4/2025 and the order is in
the orders plural kar dewa tha na. Orders dated 15/4/2025 and 24/4/2025. Hala. City can kar dewa. Apna move karantu. 41 42 Roman 2 re. But seta mo specify karuni khali quote kar do.
Only your lordship may observe that the appeal shall be adjudicated on in the light of the judgments.
No, light darkness it is binding on
that. The second
High Court rely you don't seek a direction from the court. It is binding.
Because it
is law of the land. If light High Court.
One more. Yes. In the second judgment which has been relied upon by me, in that judgment, this honorable court has specifically decided in the district of Balangir, probate of a will is not required at all.
Already dictated
and directly the mutation order has been passed.
In both the cases.
ସେଇଟା ମୁଁ ସର୍କୁଲେଟର ହେବିନି
No, in all the cases, man. In all the cases.
ମୁଁ ଆଜ୍ଞା ହାଇକୋର୍ଟ ଜଜ୍ ହେଇକି ରହିବି till my retirement or otherwise ଯଦି କଣ ହେବ କହିପାରିବିନି ବଟ୍ ମୋର ସର୍କୁଲେଟର ହବାର ନାହିଁ
ନାଇଁ ଏଇଟା ରିପୋର୍ଟେଡ
ଆମର ସେ ରିପୋର୍ଟେଡ ସବୁ ସେଇଟା ରିପୋର୍ଟ ମୁଁ ଆଜ୍ଞା ହେବିନି ଆଇ ହାଭ୍ ଏ ଚଏସ୍ ଯିଏ ଯୋଉ ଅଥରିଟି ସେଇଟା ସେ କରନ୍ତୁ ଦ୍ୟାଟ୍ ଇଜ ମାଇ ଲିମିଟେଡ ଅଣ୍ଡରଷ୍ଟାଣ୍ଡିଂ ଆଣ୍ଡ ଫିଲୋସଫି
No, on the basis of
ଆମେ ଯଦି ସବୁ କାମ କରିବାକୁ ଚେଷ୍ଟା କରିବା ସୋ ୱି ସୁଡ୍ ନଟ୍ ଆମେ କାହିଁକି
and
I can tell you
observe that my lord, you'll also observe that the
pendency of the writ petition before this court shall be considered by the appellate authority if appropriate application is filed for condonation of delay along with the appeal.
obliged.
The writ petition is disposed of. Next, after recess, time here. Again, sorry, all passed over matters. ठीक है जोड़ा आपनकर appearance से जोड़ा note करिया कथा दे देबे अपन लिखि देबे जेटा जे appear करछ. Thank you.